Good morning. Oh, excuse me. Good afternoon. Boy, I got to wake up. I'm sorry we're a little behind here. I didn't put my earphones on. So, welcome back, OCO TOE 2. This is Gary Bergman.
And I'm Michael Runyon. Good to be back in the studio with you, Gary.
Yes, yes. It's been a long time. But this is the Seventh Amendment hour, and we talk about law here. And a shout out to Miss Mary at Sunsinkers Mail Service, 50 Emory Street, next to Red Sky Barbecue. I want to mention here that the Nevada Republic Labor Coalition hoping to have a little Labor Day rally on September 7th. Hope to make this the first annual celebration. Maybe we can turn it into picnics and other stuff on Labor Day, like the old days. But we're looking for people to show up on Highway 160 and 372 at the intersection there. Bring some flags, preferably a U.S. civil flag or something from the Revolutionary War. Don't tread on me, appeal to heaven, something like that, or John Paul Jones's naval battle flag. And if you have a shirt or a hat of the trade you was in, wear that. People can see what you did for a living.
Absolutely. Built America, that built our republic.
Yeah, people don't know. Without what the building trades do in this country, we wouldn't have what we have today.
No, we'd have rocks and sticks and caves.
Yeah, we couldn't even get up and turn on a light. Get your coffee pot going. And then also, we're looking for 2 youthful hosts. The upcoming new show on the Nevada Republic Network. So we're thinking about doing a new show here.
The new web show, straight to YouTube, right online. Looking for a couple of people that are looking to get into the broadcasting industry, get a little experience going with our little web show.
And hopefully they've been listening to our show and they're a little patriotic. They understand what's going on here with the Constitution and other stuff. So we will do the script for you. Then hopefully you'll be able to pick up your own script after that. But we're looking for 2 people, or 2 youthful people, to run this show.
So the way you get a hold of us there is to email us at NevadaRepublicNetwork@gmail.com. That's NevadaRepublicNetwork@gmail.com. And we, hope to help get you started.
And if you want to do the snail mail, it's Nevada Republic Network at 50 Emory Street, Suite 500, Trump, Nevada, 89048. And or if you want to even talk about this Labor Day deal, you can get to us at either site too.
Absolutely. You can also hit us up on Facebook and follow us on Twitter.
And we're asking everybody to do a little research. You can get us online. War is a Racket, the book written by retired Major General of the U.S. Marine Corps, Smedley D. Butler. And everybody should know about this. And we're going to be talking about it this coming Saturday, ARJ. So
I want to make a statement. We are not any way paid to promote this book, or don't even know Mr. Butler. I believe he's passed away.
yeah, I believe he is. We're just letting you know, sharing you the facts that he found out. He shared with everybody. And we think everybody should know the facts. War is all about.
Absolutely. So without further ado,
yes, take it.
All right. Here on the Seventh Amendment Hour, we've done quite a bit of groundwork. That's what Gary and I have been trying to do, trying to get that groundwork laid out. We've talked about the Bill of Rights. We've talked about the amendments up to the lawful 13th. How all this ties to the common law. Well, as discussing various topics with law and justice. We're going to build on this. Like I keep saying, we're moving out of the lower division courses. We're going to build on this and start looking at the case law, which further develops our understanding of the natural law and how it's codified. Remember, this natural law is codified into the common law. All of this relates back. That's where we want to get to. We're going to start with some case law dealing in constitutional law. Your guarantee of freedom in a constitutional common law court of justice. Now remember, the courts that are out there, they're not common law courts of justice. They're corporate courts. They're set up by the unlawful, the de facto corporate government. But theoretically, they still follow this common law if they're following their own rules. So these cases are concerning constitutional common law that are enforceable in the common law court of justice. Let's start with how this all fits together. Go ahead, Gary.
Oh, okay. I just waiting to see when you
I
want me
cut in whenever you want to.
to.
You know, we don't have a set dance card here.
Okay, so the Constitution, Article 6, Clause 2. This Constitution, common laws England, in the States of America united within the Federation, which shall be made in pursuant thereof, and all treaties made or which shall be made under the authority of the Confederation of States shall be the supreme law of the land, and the judges in every independent sovereign state shall be bound thereby. Anything in the Constitution, articles are common laws of independent sovereign state, contrary notwithstanding supremacy States of America united.
Here we see some language, this important language that binds the Constitution of the several states to the common law of England. Very important section. It was the intent of the framers that the common law be the supreme law of the land, superseding all others and subordinating the laws that are made by the several states to the common law. As we have discussed, the common law is codification of the natural rights that you and I enjoy as sentient creatures, as human beings. No law, no government can strip these natural rights away. No tyrant or dictator can deprive you of them. Heck, you can't even give them away. They are your natural rights because you're a human being and remain yours, even when they're trampled by the government. And we all know how government just loves to trample your natural rights. That's what
Amen.
they do. So, the other important thing that I want to bring up here is that they're talking about pursuant to the treaties and all the other laws, and they keep referring back to the common law. Even the treaties have to obey the supreme law, the common law. That's important things. Remember, all the laws, all the constitutions everywhere, all are back to that common law, to those natural rights.
And for the ones that didn't catch us on YouTube last Saturday, we talked about this common law, how it's still used today, going back to the kings and queens laws of the 15 to 1600. They're still making ruling for cases here, present day, like even Nevada. It's old English common law that says by the king or queen, I forgot which one, I think it was Charles, says we cannot have a lottery system. That's why Nevada doesn't have the lottery.
Exactly. It says the lottery is abhorrent, which is why you have to go to Prim to buy your lottery ticket.
So latches, doctrine of latches, based upon maxim that equity aids the vigilant and those who slumber on their rights. Neglect or omission to what one should do as warrants presumption that one has abandoned right or claim. Eldridge versus Idaho State Penitentiary case. A failure to do something which should be done, or a claim or enforce a right at a proper time. Case Hutchison versus Kennedy. So you can look up these cases. And by the way, we try to print some of our scrolls out and leave them over there at Sunseekers at Emory Street. Read us something. Can't find it.
Yeah, the other thing we're going to be doing is through that Nevada Republic Network and here through the radio station, we're hoping to get these transcripts put up onto a shared drive so you can download them and read them yourself. You can actually reference the cases that Gary and I talk about. Because it's a heck of a time trying to figure out what the heck we said, Eldridge versus Idaho State Penitentiary or, Hutchinson's versus Kenny. And we're going to be making reference to a lot of cases. So get yourself a copy. So all of this harkens back to the illustration I made on an earlier show. And you got to watch a list of these earlier shows about the sandcastle of rights. So let me set the scene for y'all again. You, the individual, sit upon the sandy beach. Beautiful day. The sand is your natural rights. The ocean is the force of tyranny. Now, that tyranny can't diminish the sand in any way. It just flattens it out and it makes it all nice and pretty. It can't strip away, this is tyranny, can't strip away your natural rights. They exist whether they've been trampled or not. You sit there and you build your sandcastle. The sandcastle is your expression of your natural rights. Sometimes you get help from other people. Well, the sand, they're sitting there with their family building, and they help you build the sandcastle, and you help them build theirs. The waves of tyranny wash against your castle, and they seek to level it out, remove your expression of rights. It's only through your vigilance and the vigilance of your neighbors that castle stands. Only through the vigilance of the neighbors that theirs stand in your help. Sometimes there's a storm like the one we're in right now with COVID, all the other things going on. The waves break high against the winds of oppression blow, and the tyrant pushes hard against your natural rights, enslaving and chaining the people. It's only through the people work of the people on shore that a castle can stand, or even be rebuilt when it's been flattened. Sometimes it falls completely. Sand is still there. Your natural rights are still there, waiting to be rebuilt by the hands of the vigilant. And I often think on this when I'm out smoking my pipe or having a good cup of mead. I ask you, the listener, to do the same thing. Let's think on this for a while, because it helps me understand and motivates me to action. It motivates me to be here with my co-host and my co-teacher, trying to bring these things to light in your mind.
So now we have Marbury versus Madison, case in 1804. This is a critical case in the court of John Marshall. That was his role of courts determining if all passed by the legislature, ratified by the executive, passes muster against the test set forth in Articles that subordinates all law to three things: common law, the Constitution, national. The history of the case wraps around ongoing ideological conflict between old friends Adams and Federalists, Jefferson and anti-Federalists. This is the same struggle that we still seek to grow the power of central government. Those who wish smaller centralized. March 2nd, 18, days before his presidency ended, John Adams, nominated nearly Federalist supporters, judge and justice of the peace positions, Federalist Code Congress, a newly created with the Fishery Act of 18.
Called court packing, and we've seen it happen over and over again.
So these last Senate nominees, Jefferson supporters, derisively referred to as midnight judges, included William Marbury, prosperous Maryland, adjunct Federalist. Marbury was active in Maryland politics, vigorous at the presidency.
Now, the following day, March 3rd, that used to be when, well, March 3rd was the last day of a presidency, and March 4th was the beginning of the new presidency. Following day, March 3rd, the Senate, controlled by the Federalists, approves Adams' nominations. Basically just gives them a rubber stamp. These appointees and commissions were sent out immediately, then signed by Adams and sealed by the Secretary of State, John Marshall. Later became the now named the new Chief Justice Supreme Court in January, but continued serving in both roles, both Secretary of State and Chief Justice. Marshall then dispatched his younger brother James Markham Marshall to deliver the commissions to the appointees. With only 1 day left before Jefferson's inauguration, Marshall was able to deliver most of the commissions, but a few, including Marbury's, were not delivered. Like I said, that next day, March 4th, 1801, Thomas Jefferson became president, the third president of the United States. As soon as he was able, Jefferson instructed the new Secretary of State, Mr. Madison, to withhold the undeliverable appointments. Right. Jefferson's opinion, the commission were void because they had not been delivered in time. With no commission, the appointees were not able to assume office and their duties which they had been appointed.
So over the next several months, Madison continually delivered Marbury's commission. Finally, in December 1801, Marbury filed suit against Madison and the Supreme, asking the court to issue a writ of mandamus, forcing Madison to deliver his. The lawsuit resulted in a case of Marbury versus Madison. The case was not decided until February 1801 because of the retaliation for Adams' appointment of midnight judges. Jefferson, Democratic Republican congressman, successfully passed a bill that canceled the court's 18. So all pending cases, Marbury and Madison not decided until 18.
And you thought our politics was petty these days. So coming from that decision, No provision of the Constitution is designed to be without effect. Anything that is conflict or that is in conflict is null and void of law. Clearly, for the second law, the secondary law come in conflict with the supreme law was illogical. For certainly the supreme law would prevail over all the other laws, and certainly our forefathers had intended that the supreme law would be the basis of all law, and that any law that to come in conflict would be null and void of law. I'm reading this as Supreme Court decision. It's all legalese. Sorry if I stumble over it. It would bear no power to enforce. Would bear no power to
Obligation.
or an obligation to obey. It would purport to settle as if it had never existed. For unconstitutionality would date from the enactment of such law, not from the date so branded in an open court of law. No courts are bound to uphold it, and no citizens are bound to obey it. It operates as nearly nully or fiction a law. So, like I said, sorry I trip over that. That's the part of the decision reached by Mr. Marshall.
We have to keep as the content. So if any statement within any law which passed is unconstitutional by Marbury versus Madison, Shepard citations. Group of court reporters that go through track of all court cases have come before courts, especially and they clarify for the court all cases which have cited Marbury versus Madison case to the court has not ever been overturned. Keep that in mind. See Shepard citation of Marbury versus Madison, Title 5 U.S. Code, Section 556, 557, 70.
Now, Shepard citations are the go-to when looking at Supreme Court cases. It's a great book. You can pick it up off of Amazon again, and you know how I feel about them. But it's a nice big thick tome, has all the citations you're going to need. Courts lose jurisdiction if they do not follow the due process of law, and that's from Title 18 U.S. Code, Section 2381.
So, in the presence of two or more witnesses, same overt act or in an open court of law, if you fail to timely move to protect and defend the Constitution of the United States of America United and honor your oath of office, you are subject to the charge of capital felony treason.
I want to throw some commentary here. It's just remember the gist of Marbury versus Madison is any law that's in conflict with the common law or the U.S. Constitution of the various states, that law is if it never existed. That law never happened, and
null and void.
Null and void. That's what all that meant. But as we've discussed over and over here, the oath taken by nearly every federal employee, that includes all of you in the de facto armed force, the corporate armed forces, all of you who ever worked for any government agency. Protect and defend the Constitution of these various states united against all enemies, foreign and domestic. Heck, I took that oath too when I worked for the Department of Interior. Now, how often do we see these people in government, these government functionaries, overtly violating their oath? I can literally count hundreds of times that I personally witnessed when I worked for Department of Interior. I would like to see this section of code we just cited, U.S. Title 18, U.S. Code, Section 2381. You can go ahead and look that up. I'd like to see it acted upon more frequently and with the same kind of vigor that the government uses, prosecutes people for even missing 1 penny of their extortion that they call income tax. I'd love to see them use the same kind of resources they came after an old man in Illinois for missing 8 cents out of his property taxes and seized his house. The only problem, I think, is we would swiftly run out of tree limbs and rope, rounds of ammunition to deal with all the treason in our government.
So now we have the American Jurisprudence Book, 16, Constitutional Law. And they got sections on here, 16 American Jurisprudence, let's say JUR, 2D, and 16 AM JUR, 2D, Section 97. You go to the American Jurisprudence Book 16, Constitutional Laws, look this up.
Get another nice big thick law book available on your various bookseller sites. It's another good one to check out from your library.
Then the Constitution shall receive a literal interpretation in favor of the citizen, especially true with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to person and property. This is
Shall
very
not be shall not be infringed.
this was Berry versus the United States. Any constitutional provision intended to confer a benefit shall be liberally construed in favor in the clearly intended and expressly designated beneficiary. You are the beneficiary of the U.S. Constitution.
And this is how it should be. We discussed here, we the people created the government. Government is subordinate to the people. Any action of a just government must be for the benefit of the people, not for some sole benefit of the government. Often in our de facto government, we see just the opposite. The government acting for the increase of government, increase of power, and the diminishment of the people, and for the people that are employed by the government to feather their nest. And again, like I said, I'd love to see that law we mentioned above acted on much more vigorously. Heck, I'd like to see it acted on just once.
So we're back to the 16 AM JUR 2D, and this is section 98. An emergency can create power, and no emergency justifies the violation of any of the provisions of the States of America Constitution or state's constitution. Public emergencies such as economic depression or especially liberal construction of constitutional powers, and it has been declared that because of national emergency, it is the policy of the courts of times national peril so liberally to construe the special powers vested in the chief executive as to sustain the effectuate the purpose thereof, and to that end also more liberally to construe the constitutional division and classification of the powers of the coordinate branches of government, and insofar as may not be clearly inconsistent with the Constitution. Legalese, I hate it. No emergency has just cause to suppress the Constitution.
And we can see that in the rulings against Roosevelt. We can see that in the rulings against Lincoln. Heck, we hopefully will see that in the rulings against the current government.
That's right, because remember, no emergency has just cause to suppress the Constitution, and we're having our rights violated almost 100% here.
You know, we see these emergency declarations, these executive orders, and I am absolutely 100% positive that as hurricane season continues, and that as these hurricanes make landfall on the Gulf Coast in Florida, we're going to see emergency declarations. We're going to see emergency declarations that are clearly in conflict with the constitutional, the natural rights of man. We see these pocket tyrants, these governors, these mayors, these city council people, using every emergency they can to justify the increase of their personal power and wealth, and to diminish the rights of the individual, or even manipulate on the international scene to their best interest by doing what the federal government does best, bombing brown people. Remember, every time we drop a bomb, they're expending thousands to millions of dollars of money extorted from you. Do you know who owns those companies? F. Feinstein, I'm looking at you and your husband. Because your husband is a war profiteer.
Yep.
And you, by extension, are a war profiteer. You voted for the war and made sure we were dropping these bombs that came out of your husband's company.
And remember, we talked about this definition of mandate, the legalese term, and it means that an order signed by a judge, not by executive of a governor or a mayor, county commissioners, by a judge. So that mandate they have posted at the store, it's not lawful. So keep that in mind. They're just buffaloing. You're lying to you. So we're here to 16 AM JUR 2D section 114, American Jurisprudence.
Yep, working for that same book here.
That same book. As to the construction with reference to common law, an important canon of construction is the constitutions must be construed to the reference to the common law. The common law so permitted destruction of the abatement of nuisances by summary proceedings and was never supposed that a constitutional provision was intended to interfere with this established principle. And although there is no common law in the United States, federal customary law, as distinguished from the common law of England, adopted in several independent sovereign state republics, in interpreting the federal constitution, recourse may still be had the aid of the common law of England. It has been said that without reference to the common law, the language of the federal constitution could not be understood. Common law of England is still a reference.
Mouthful, isn't it?
Yeah.
The simple terms is that a restatement of the facts there's no separate common law for the several states. Rather, the several states speak first English colonies, save Louisiana, and, you know, have heritage in English common law. It makes sense that the common law and natural expression, the natural law, we don't need to rewrite it for the Americans. For the Americas, we already have it. We have it as our heritage as coming from England. We don't need to rewrite the common law. It exists in expression.
So once again, we have the 16 AM Jur 2D, Section 155 of the American Jurisprudence. Since the Constitution is independent observation of the judiciary as well as other departments, and the judges are sworn to support its provisions, they are obligated to support it. The courts are not at liberty to overlook or disregard its commands or counteract evasions thereof. It is their duty in authorized proceedings to give full effect to existing constitution and to obey all constitutional provisions, irrespective of their opinion as to the wisdom or the desirability of such provision, and irrespective of consequences. Thus, it is said that the courts should be and are alert to enforce the provision of the States of America Constitution and guard against their infringement or legislative fiat, otherwise in accordance with these basic principles. The rule is fixed that the duty, the proper case, to declare a law unconstitutional cannot be declined, must be performed in accordance with the delivered judgment. A tribunal for the validity enactment directly drawn into question. If the Constitution prescribes one rule, the statute the other in a different rule, it is the duty of the courts to declare that the Constitution and not the statute governs in cases before them for judgment. But it seems like it's reversed nowadays.
Absolutely. And like I said, we're not in that 100 level course here anymore, folks. We're in that upper division. So this is a reflection of the opinion that my co-teacher and I have of you all. You're intelligent. You're wise. You're going to be able to handle these type of things. Heck, you're listening to us. I mean, you're taking that first step. What's being said here is that the judge and the courts are bound by the law, the common law, and not by their own opinion of justice. That's left to us, we the people in the jury box. Judge the law as well as the facts of the case. And according to, Seventh Amendment, once we judge as a jury the fact, it cannot be overturned. This is critical, since judges at the Supreme Court level are going to be interpreting the law and its constitutionality. They're that last line of defense against an unconstitutional law. This can be seen in some of the cases with results fly in the face of what we would see now as individual liberty. For example, Dred Scott versus Sandford. The law was plain regarding the citizenship of black people, regardless of their status as freedmen or the personal opinion of what the justices saw as liberty. The opinions of several justices laid with Scott that he should be a citizen, but the court was forced, because of the matters of law, because of the constitutionality, to rule in favor of Sandford. Clearly, we no longer see this level of principle in the judges of the court. We see them, divided. You have the conservatives on the one hand and the liberals on the other hand, and Judge Robert middle. We don't have principal justices. We don't have the John Marshalls. We don't have the John Jays. We have people with their own personal opinions interpreting the law, interpreting the constitutionality of the law.
That's illegal.
And it's patently illegal, exactly.
So once again, we're still at 16 a.m. Juror 2D. Now this is section 177. Declaratory judgments, actions have often been utilized to test the constitutionality of a statute practices. Uniform declaratory judgment makes specific provisions of determination of construction or validity statute and municipal ordinance by declaratory judgment considered to furnish a particularly appropriate method for the determination of controversies related to the construction, validity, statute, and of ordinance. Federal Declaratory Judgment Act, although it does not mention declarations as to the construction or validity of the statutes, has been involved frequently as a means of assaying of the constitutionality of congressional legislation. A plaintiff can have a declaratory judgment action on the constitutionality of either the federal or state statute by a single federal judge, so long as he does not ask to have the operation of the statute joined. A court may grant the
declaratory relief unless there's a case of controversy before the court. So what this means is no one is bound to obey an unconstitutional law.
That's right. Let's just keep it simple.
A declaratory judgment. What the declaratory judgments are is they're oral arguments or written arguments before the court as to why a particular law is unconstitutional.
See, all that, what was that?
Two paragraphs.
Two paragraphs, and if you break it down, get rid of that legalese, it's no one is bound to obey an unconstitutional law.
So I would take this one step further. It's my personal opinion, not a matter of law. I strongly believe that it's the duty of a just man to act within justice, regardless of the law. The law is just, then you're going to be acting in accordance to the law, regardless if the law exists or not. Like, for example, I don't think I would steal Mr. Producer's stuff because I'm a just man and I respect him. Now, if there was no law preventing me from doing that, I still wouldn't take the stuff here in the studio. Why? Because I respect my producer and I wouldn't take his stuff. Likewise, a just man should not act in accordance to an unjust law, but rather transgress it in the name of justice. Act in a just manner regardless of the law. No one's bound to obey an unjust or unconstitutional law. If the Constitution allows an injustice, then it must be abolished or amended. We rule government, not the other way around.
Well, once again, we're in the same law book, section 56. The general rule is that an unconstitutional statute, whether federal or state, while having the form and name of law, as in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the enactment and not merely from the date of the decision. So braining it an unconstitutional law is in legal contemplation, then inoperative as if it never had been passed. No repeal of enactment is necessary. Unconstitutional law is void. The general principles follows that it imposes no duty, confers no rights, creates no office, shows no power of authority on anyone, affords no protection, and justifies no acts performed under it. A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. Persons convicted and are fined under statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one. An unconstitutional law cannot operate to supersede existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, is superseded thereby. Since an unconstitutional statute cannot repeal or in any way affect an existing one, if a repealing statute is unconstitutional, statute which it attempts to repeal remains in full force and effect, where a clause repealing to a prior law is inserted in the act, which act is unconstitutional and void. Provision of the repeal of the prior law will usually fall with it and not be permitted to operate as repealing such prior law. The general principles stated above apply to the Constitution as well as the laws of the several states, insofar as they are repugnant to the Constitution and laws of the state of America.
I'm glad Gary read that because I certainly
I forgot one word. United.
There we go.
States of America United. Yeah, now where's the translation of it?
Yeah, that's what I'm working on here. The translation of all this, I'm glad he read it because I couldn't have gotten through it if I tried. So effectively, what it's saying is when the courts rule that a particular act is unconstitutional, doesn't matter what kind of act, doesn't matter what it does, it's unconstitutional, it's as if it never existed. So if it repeals a law, the law it repeals is still in effect and was in effect the entire time. Likewise, if it makes something new illegal or makes something new legal, it's as if that never happened. Back to the date. It's an undo. It's a mulligan. If you play golf, you know what a mulligan is. It's as if it never happened. That's a good thing. It helps people that are convicted under an unlawful act recover be made whole for what happened. It likewise means that a contract that you were forced into under an unlawful act never existed. You aren't bound by it.
Just like they're counting you these driver's licenses contract. Well, no, they're not. There's a non-disclosure act right there, non-full disclosure, so that's null and void.
Exactly. If you're not fully informed of the terms of your contract, it is not enforceable. Now, it falls on you to actually read the contract. And, if you don't, that's on you. You screw up that way.
But if it ain't stated in the contract.
But if it's not stated, exactly.
Like these military enlistment contracts, and they don't tell them they're working for a corporation, a foreign corporation. So that's makes that null and void.
Exactly. So anytime something gets ruled unconstitutional by the courts, and if we had a valid court, we could actually make that happen. It's as if the law never happened. Now, one could actually even interpret this whole thing because I personally claim, I know Gary would follow me on this, that any act brought into force after March of 1861 is technically unconstitutional.
Yeah, in fact,
follow me on? Okay.
The other day was the celebration, I think, of the 19th Amendment, the Women's Voting Act. Well, I'm sorry to tell you, that's not constitutional.
No, because
that's a corporate bylaw. So
it's well and good. It's a corporate bylaw. I'm sure if we had a just republic, if we had a legitimate Congress sitting in there, it wouldn't be a big deal to get that rammed through.
We don't have a lawful government right now.
We don't have a lawful government right now.
So you're celebrating for nothing.
All that fight, all that struggle, all that time fighting against a government, that was trying to repress women's rights. It wasn't a government, it was a corporation.
That's right. So you got lied to.
I think the propaganda minister for that short Austrian corporal once said, you tell a big lie often enough, people start to believe it.
Right. That guy with the funny...
That's got a funny mustache. You know what? I got better facial hair than he did, so... That was his problem, is he couldn't grow facial hair like mine. He was a little unhappy.
So we're in the same section of the law books, and we're doing section 258 here. On the other hand, it is clear that Congress cannot, by authorization or ratification, give the slightest effect to a state law or constitution which is in conflict with the federal constitution.
Exactly. All this is saying is you can't have state law or even state constitutions that violate the federal constitution. You have the supremacy clause, which is one of the first things we read to you tonight.
That's Murdoch versus Pennsylvania. That was the case in 1903.
And we cite these cases that are in the federal court because, you know, that's what you're taught in school, and that's what you understand. And you got to understand how these are interpreting.
We're not just picking this stuff out of the sky. We're telling you actual cases,
Well,
actual rulings.
a state may not impose a charge for the employment of a right granted by the federal Constitution, and that a flat license tax here involves restraints in advance. Constitutional liberties of press and religion, and inevitably tends to suppress their existence. It- that the ordinance, in this case of Murdoch versus Penn, is not discriminatory and that it applies to peddlers of wares and merchants is immaterial. Doesn't matter. Liberties granted by the First Amendment are in are in a preferred position. They take precedence, since the privilege in question is guaranteed by the federal Constitution and is independent of the state's authority. Inquiry as to whether the state has given something for which it cannot ask in return is irrelevant. No state may controvert any secured liberty into a privilege and issue a license and a fee for it. Now, I would love to see a lot of states sued over this. I would love to see the state of California ripped to shreds over this. I would love to see the state of New York ripped to shreds over this. Because this is exactly what they're doing. They're implementing a flat license tax, a license tax, and they are using it to restrain the rights of the individual. They're using it to restrain the rights in the individual case in New York and California to protect themselves. Again, shall not be infringed. The right of the people to keep and bear arms being necessary to the security of the free state.
Cannot take a right and make it a privilege, license it.
Exactly. Like the right to travel. Like the right to keep and bear. Like the right to be able to express your opinion. Petition your government for redress of grievances. And this actually brings me to something in the news recently. I don't know if you read about it or not, but our good friend Mr. Bundy just got arrested again. What? Yep, got arrested for trespassing because he, quote, unlawfully was in the press box. Well, hang on. Yeah, this was at a convention or a rally of some kind for a Republican Congress critter, and he was there as a citizen journalist. Sat down in the press box because he's a journalist. Well, the Capital Correspondents Association, again an arm of the government, licensed and made legal by the government, said, "No, you can't be a correspondent. You haven't paid us the license fee."
Oh, nonsense.
So they literally drug him out, handcuffed to a chair.
That's a life's lawsuit.
It's going to be a great lawsuit. The people who pay for it, sadly, are the ones that had their money extorted from them.
Right. Sure, when is it?
Yesterday evening.
Oh.
As we stay up on the news here, at least I try to.
What station did you?
I picked that up off of Reddit website. Reddit. It's a
Oh, you got it off Red website. Okay.
Yep.
All right.
So moving on here to Shuttleworth versus Birmingham, Alabama, 373 U.S. 62 out of 1962.
So if the state does convert your right into a privilege and issue a license fee for it, you can ignore that license and a fee and engage the right with impunity.
Absolutely.
Now, we know darn well we can't do that because they'll turn around, throw cuffs on you, and then maybe shoot you in the back when you're unarmed, like 7 times. Then worry about justification later.
Well, they'll figure something out to charge you with. They'll dig something out of your past. Or, as the TV show South Park once said, just sprinkle a little crack on it, we'll be okay.
Well, yeah, this whole system, country is terrible.
It is a terrible, unfortunate situation, and it references back to something we talked about earlier. If you aren't engaged in using your rights, engaged in enforcing your rights,
You have no
engaged in
rights.
defending your rights, they don't exist.
Right.
Well, they still exist. They still are there. But the tyrant willfully tramples upon them, and you have no way of stopping them.
So we have the United States versus Bishop.
So
And
it sets the standard for
oh,
criminal violation of willful intent. So this is all going to be paraphrased here because this whole thing is huge.
yeah, now and pay attention what he's telling you here on this this criminal violation of willful intent. What they must prove.
That you must be proven that you are the party. The problem that's going to happen there is they're going to cite your name in all capitals. That's your corporate identity,
That's not you.
not you. Must be proven that you had a method or opportunity to do the thing. That makes good sense. You can't be charged with something if you couldn't have done it. It must be proven that you did this with willful intent. Now, willfulness here, we want to go and talk about the
Please.
legalese. Evil motive or intent to avoid a known duty or task under the law with moral certainty, or obviously to willfully do that with an evil intent. Now, so many of these statutes, so many of these things, the tax code, for example. A wonderful thing, and I saw it online, a meme. So we're going to extort money from you, says the federal government. The guy says, okay, how much? Well, we know exactly how much we want to extort. We're going to extort from you, but we're not going to tell you. And if you don't give us the exact number that we're thinking of, we're going to throw you in a cage. The guy has no willful evil intent. He says, well, how much? But that's the way the federal tax code works. If you don't give them exactly what they think you're supposed to be giving them, you could be doing it by accident. Heck, that thing is 78,000 pages long. If you don't follow it to the letter, they're going to come after you.
Remember, the Internal Revenue Service, the corporation formed out of Wilmington, Delaware, early 1900, I think it was the 20s. They're private collection agents, not a government agency.
Now, here's the other interesting thing, Gary. I don't know if you knew this, but the income tax was ruled unconstitutional.
Oh, yes.
And then, well, they made it constitutional, I believe with the 16th Amendment, making an income tax law illegal.
Remember, 16th Amendment. That's 3 amendments after the 13th, so it's not lawful.
3 amendments too late.
Right.
So it's not lawful.
It's a corporate bylaw.
The reason the first guy who put an income tax into place is our favorite tyrant, Mr. Abraham Lincoln. He needed to finance his war of aggression, so he put in an income tax. Ruled it unconstitutional. So, remember, you have to have the following. You must be the party. You must have a method, an opportunity to do the thing. You must have willful intent. Don't have all three of those, that conviction's no good.
So we got Boyd versus United States. Did I catch you up?
No, you're good, Gary. Carry on. I was going to start reading it.
Okay, the court is to protect against encroachment of constitutionality and secured liberty. It is equivalent to a compulsory production of papers to make the non-production of them a confession of the allegation, which is pretended they will prove. The seizure of
compensatory production of a man's private papers to use as evidence against him is equivalent to compelling him to be a witness against himself. Hey, that's a violation of the Fifth Amendment. And in a prosecution, crime, penalty, or forfeiture is equal with the prohibitions of the Fifth Amendment. Sorry.
So translate.
What this is all saying is right now when they demand your papers, please. They're doing it to try to convict you of a crime. And if you are unwilling to produce those papers, as is your right under the Fourth Amendment, they need to produce a warrant. They're going to charge you with the crime of not producing your papers.
Know your rights.
Know your rights. This even goes as far as, and it's a wonderful case, interesting case, of a guy who's being accused, and I don't support this in any way, one way, shape, or form. He's being accused of they have no actual evidence of this, of being in possession of child porn. Now, he's got an encrypted hard drive in his computer, and they are compelling him to produce the password to it. And the way they're doing it is they're holding him in prison under contempt of court. Now, they can't prove he did anything. They have no other evidence. They have no witness against him. They don't even know how he got the stuff. They just say, it's there. It's on your computer. And if you don't give us the password, we're going to hold you in prison forever.
That's terrible. That's contempt, and they can do that for as long as they want.
Exactly. Contempt. They drag you back in every 14 days. You got the password yet, buddy? No, it's against the Fourth and Fifth Amendments. Back to jail you go.
Well, that's when you got to do something else. Habeas.
Submit rid of habeas corpus. Produce the body.
So we have another case. Norton versus Shelby County. An unconstitutional act is not law. It confers no rights. It imposes no duties. Affords no protections. It creates no office. It is in legal contemplation as inoperative as though it has never been passed.
Acts of a person assuming to fill and perform the duties of an office which does not exist have no validity whatsoever in law. Now, this is critically important here in the territory of Nevada, because that's exactly what we are. We are a territory, because the documents for statehood were not put in motion, not put in place until after March of 1861, which we ceased to have a lawful Congress. Lawful Congress is what makes a state happen. But what does this say? This says an office, a person assuming to fill and perform the duties of an office which does not exist. If we're not a state, we have no governor, cannot exist, and can have no validity whatever in law. So all the laws of the state of Nevada are null and void. They don't exist.
And what happened in 1863?
1863, there's a lot of things that happened in 1863.
Well, the main thing, General Order 100.
Oh, yes, General Order 100. Martial law.
Second time.
Yes. Martial law, that's that corporate military flag that you see people flying, the people that have been hoodwinked, thinking they are patriots, flying over their house.
You're honoring Queen Elizabeth I, East Indian Trading Company. This is the reborn again East Indian Trading Company here. This United States
We're a corporation.
Scotland.
Oh, there we are.
We got the U.S. versus Doherty. The jury has unreviewable and unreversible power to acquit in disregard of the instructions on the law given by the trial judge.
This here is one of my favorite court cases. This actually enshrines in constitutional law your duty as a jury member for jury nullification. Your duty to judge the law. Not what the judge tells you, not what the prosecutor tells you, but judge the justice of the law and how it is being applied in this case.
Common sense.
Now, mind you, the judge thinks he has absolute power in his courtroom to hold you in contempt if you even mention jury nullification. Heck, he'll throw you out on your own. Get out of here. You're not going to be on this jury because I am the law. Quote Sylvester Stallone out of Judge Dredd. Now remember this. You are a critical safety valve. You're a critical safety valve for justice. That jury box is that final box before we start breaking out the ammunition. You are the one standing between that federal corporate government, that illegitimate government, and us having to break out the cartridge box. Because all you have to do is say, no, I'm not convinced. He's not guilty. All you have to do. Heck, what you could do here in Nye County is join Gary and myself and our other friends and form the grand jury here in Nye County. That's an important step. It's a right guaranteed by the U.S. Constitution that no indictment can be made except for by presentment by the grand jury.
Nobody in Nye County cares.
Well, the least I can do is push it out there. Try to get some. One person. If I can get one person.
They're all asleep at the wheel.
Well, and that's why we're here. Why we're here. Wake up, Mr. and Mrs. America. Get that coffee going. We'll cover one more. I think we have time for one more case here. The U.S. versus Boylan. 14 FD2, 1002 to 1006. Go ahead there, Gary. Read this one in.
We recognize as appellants urge the undisputed power of the jury to acquit, even if its verdict contrary to the laws given by the judge.
But just what I said before. This is jury nullification. It's your job.
Now, we refer here to the Texas Constitution. Article 1, Section 19 states, no citizen of this state republic shall be deprived of life, liberty, property, privileges, or immunities, or any manner disfranchised except by the due course of law of the land. And that's actually the law for every state.
Absolutely. The law of the land is the common law. The common law of England is the law of the land. It's simple, very simple. That common law governs everything. And
So-
we're being deprived every day of life, liberty, property, privileges, and immunities.
Barnett, Mass, you're being deprived right there. Now, due process of law.
Being put on house arrest.
Yes. Did you go to trial? You have a trial by or indictment by a grand jury and put on a trial by a jury? Was there a decision to put you in house arrest?
Having
No.
your property despoiled, your business.
You're being ruled over by a dictatorship, military dictatorship.
All it takes, there's more of us than there are of them. When we start standing on our own, when we say this far and no further, when we, like the Irish, say we will refuse to recognize their institutions, the only institutions we will recognize are our own. When the only institutions we recognize are things like the private membership organization. When we recognize the territory of Nevada. When we recognize only our own institutions and not theirs.
And now we have two court cases for the Supreme Court that were ruled on in 1982, pretty recent. One is Owen versus Independence, and the other one is Maine versus Thibodeau. Officers of the court have no immunity when violating constitutional rights, liability. So, in other words, when any public servant violates your rights, they do so at their own peril. You can
Exactly.
sue them. There's laws that protect you.
This absolutely destroys that false concept of procedural and immunity granted to, the officers of the court. It destroys procedural immunity for a judge who holds you in contempt for expressing your constitutional right, demanding a trial by jury.
And we got one here a lot of people don't know about, and this is right from the U.S. Code website of the government. This is Title 18, U.S. Code Section 4, misprison of felony.
So whoever having knowledge of an actual commission of a felony cognized by the court of the United States conceals and does not, as soon as possible, make it known to some judge or other person in civil or military authority under the United States shall be fined under this title or imprisoned for no more than 3 years or both. So if you have knowledge, actual knowledge of the court committing a felony, of the officers of the court committing a felony.
Now, this comes down to what we said before. The bailiff is there to protect you, not to protect the judge or anybody else behind that barrier. They're there to protect you. And if they don't protect you when there's a violation of your rights, they can go to jail under this section right here. So that's Title 18, Section 4, prison of felony. Make sure you know that. Now, here's two more here. We're going to get on real quick.
Push in here.
You need to know these.
Title 18, U.S. Code, Section 241, conspiracy against rights. It's one of my most favorite. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in the states, territories, commonwealth, possessions, districts, in the free exercise or enjoyments of rights or privilege secured to him or her by the Constitution or laws of the United States, or because of his or her having exercise of the same, or if two or more go in disguise on the highway or on the premises of another with intent to prevent or hinder his free exercise or enjoyment of any privilege, right, or privilege so secured, shall be fined under this title or imprisoned for not more than 10 years or both. And if death results from such acts committed in violation of this section, or if such acts include kidnap, attempt to kidnap, aggravated sexual abuse, attempt to kill, they shall be fined under this title or imprisoned for a term of years or life or both, or may be sentenced to death. Now, here's an important part of this: in disguise. Guess what all those nice little police officers and federal agents do?
Unmarked cars.
Unmarked cars, and are wearing balaclava masks. That is their identity. They are in
Violation
disguise.
of the law.
They are violating the law. But no one cares. No one is willing to stand.
Right. No one wants to read. So let's, real quick, Frank, let us get this last one in, then we'll call it quits.
Title 18, U.S. Code Section 242, deprivation of rights under color of law. We've read this one in before. Whoever under color of law, statute, ordinance, regulation, or custom willfully subjects any person, any state, territory, commonwealth, possession, or district, deprivation of any rights, privileges, or immunities secured or protected under the Constitution and the laws of the United States, or to different punishments, pains, penalties, or accounts of such person being of an alien or reason of his color or race, will be prescribed for the punishment of citizens, will be fined under this title or imprisoned not more than 1 year or both, or if bodily injury occurs, the acts committed in violation of this section, or if such acts include the use, attempted use, threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title or imprisoned for no more than 10 years or both. If death results from the act committed in violation of these sections of action, or if the act includes kidnapping, attempt to kidnap, aggravated sexual abuse, attempt to commit aggravated sexual abuse, attempt to kill, they'll be fined under this title or imprisoned for any term of years or for life, or both, or may be sentenced to death. Again, I would love to see this acted upon as vigorously as they do the tax.
So keep in mind, read this and understand what it's saying. This pertains to police officers.
Any officer of the court, really, Gary.
That's right. But I mean, people in particular, when they're getting pulled over, if they're getting handcuffed, there could be a kidnapping charge right there. Or if you've been sexually abused during this arrest, right there gives you protection.
Absolutely. So make sure you go do your homework, ladies and gentlemen, Mr. and Mrs. America. Go do your homework. Go read these things. Gary and I can't cover everything in an hour for you. You have to go out and do it yourself.
In fact, there's a lot of things we didn't cover here, and we'll probably try to pick up on them next week.
Absolutely. We'll be back.
Yes. So just keep in mind, there's so much to learn.
Heck,
but if you don't learn it, you're not going to have no rights. So.
Absolutely. And like we said, we gave out that Nevada Republic Network at gmail.com. If you want to email us, rant at us, yell at us, tell us we're stupid, ask us for help, whatever you want to do, that's the way to get a hold of us right now.
And remember, we're looking for 2 youthful co-hosts, anchors, for our new show coming up on YouTube.
Absolutely. Well, thank you, Mr. and Mrs. America. I'm Michael Runyon.
And I'm Gary Bergman.
Remember, Chucky our law, our day will come. And thank you for listening. Have a great week.
Thank you very much. Bye.